Good afternoon. So I'm going to discuss documentary evidence, and before to proceed, Anna, let us know first what is document. So what is document DI? A document is a deed, instrument, or other duly notarized paper by which something is proved, evidence, or set forth. So ang meaning ani niya is ang document DI is a written agreement, instrumento, or naka-notarized na papel nga nakamamatuod sa isa ka butang. Now, let's proceed to documentary evidence. Unsa di ay ang documentary evidence matud sa rules of evidence? It states in the section 2 that document as evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Kato akong mga gistate, mao to sila ang admissible nga document. And also, documentary evidence is offered as proof of evidence. Like, for example, nagkuan ka type recording, unya, nay particular words were uttered. And sa diha, it constitute a documentary evidence. Kay, sa dira na example, kayo offered that the speaker is maujud ang iyang gistorya sa time nga record na. And it deals with the content of the evidence. Ma-question na nimo ang content sa evidence. Documents under the rules on electronic evidence. Under Rule 3 of Electronic Documents, Section 1 define that electronic documents as a functional equivalent of paper-based documents. Whenever a rule of the evidence refers to the term writings, documents, record, instrument, memorandum, or any other form of writing, such terms shall be deemed to include an electronic document as defined in these rules. To make it more understandable, electronic evidence as a bridge that allows digital files to be treated with the same legal weight as physical piece of paper. In the Philippines, the presentation and admission of electronic documents are governed by the rules on electronic evidence. Under these rules, electronic documents are considered the functional equivalent of paper-based documents, provided they meet specific criteria for authentication and integrity. It emphasizes that electronic documents kay equivalent na siya sa naka-paper-based nga documents. Same na sila og kanang legal weight. And provided by that, dapat ma-meet niya ang specific nga criteria para sa authentication o integrity sa electric document. What count as an electronic document? So, ang makount na electronic documents are text messages, emails, data stored in a computer, and also CCTV footage or photo saved on a phone. Provided by that, dapat kanang text messages, emails, or data stored in a computer, a CCTV footage or photo saved on a photos, kay wala na siya gi-re-edit, gi-edit, or gi-authored, or gi-destroy, gi-delete, na gipang-delete, or basta ka na makaguba gani sa genuinity sa usa ka document. There are also a specific criteria for electronic evidence na adiha ang admissibility and the best evidence rule, or what we call original document, authentication of electronic documents, and burden of proof. So here's sa admissibility and the best evidence rule. You really have to produce the original document to the court. But if it's digital, it's like an email or a chat, dili ra ka angay mabala ka because your printout is makonsider na siya na original as long as accurate ang iyahang reflect sa data and it is authenticated. So it's like functional equivalent na siya to paper. Like para sa to ako pa explain ganina about sa electronic evidence nga kana siya is mas same na sila legal weight sa kanang physical paper document. And here's sa authentication of electronic documents, dapat siya, naka-authenticate jud siya because you cannot just hand over a printed email man good. You have to prove it hasn't been messed with. Like ang integrity gani sa electronic documents dapat naa gyapon dira because once gani nga naara nay gamay nga masayop dira, imuhang document is mess up na jud na siya. Mawala na there ang content sa document and questionable na nuuna siya because nalahi naman ang imuhang original copy nga naa sa imuhang data stored sa imong computer unya lahi sad ang nakuan sa imong printout. And here comes the burden of proof. So basically, the burden of proof is ikaw jud ang mag-effort to prove na your evidence is real. So if you show like for example, Facebook chat, ikaw jud ang kailangan nga mo-authenticate ana. Evidentiary concept involved in the presentation of documentary evidence. So naa diri ang the best evidence rule or what we call original document rule, secondary evidence, the parole evidence rule, and last is the authentication and proof of documents. So on the evidence rule, section 4 of original of document, section 4A, the original of the document is 1. The content of which are the subject of inquiry. Ang section 4B, which a document is in the two or more copies executed at or about the same time, with identical contents. All such copies are equally regarded as originals. And section 4C is when an entry is repeated in the regular course of business, one being copied from another at or near the time of the transaction, all the entries are likewise equally regarded as original. So in the section 4A, ang pasabot dira is the original is the literal paper where man the info was first written. If we're arguing about what's inside the contract, you have to bring the exact piece of paper. So in the section 4P, ang kuana na niya kay duplicate originals. So if a document was made in two or more copies at the same time and naa sila and they have the exact same content, all of them are considered na siya na originals. So, for example, okay, if you and your friends sign two copies of the same contract at the same time, parehas ra na sila duha considered as original. It's like having twin documents. No one is just a copy because they were both man god executive sabay sa kana and they carry the same weight. And here's the last kaning section 4C kay common siya no when an entry is repeated in the regular course of business from one another at or the near the time of the transaction. Yeah, diba dingan man to nga ma-considered siya na originals. Like for example, this one is for those super busy businesses man good na siya. Like if a bank or a hospital, busy ba na sila. So, nagkuhan sila copies info from a logbook into their system dayon or within the same day. All those entries are considered na siya nga original since it's their routine and dool ra ang time sa pagcopy. The law trusts it, dili na kailangan mag-order of reference. They're all equally legit. Ari na sad ta sa secondary evidence. So, sa secondary evidence na siya upat ka box section nga nagkuan sa secondary evidence which is the section 5, section 6, section 7, and section 8. So, ari sa ta first sa section 5. When original document is unavailable. So, meaning ana niya is, this is for when the original is nawala jud siya, nasunog, or na-destroy jud siya. But wait, you can just say nawala. You have to prove to the judge na you really search for it and wala jud kay bad faith. If the court believes you, then you can now show your photocopy as secondary evidence. Sama na siya ang pasabot sa section 5. And here's the section 6, when original is an adverse party custody. So here in the section 6, para mas masabot siya, for example, this happens when ikaw ug imong kalaban is your kalaban is the one holding the original and gi-refuse nila nga ihatag sa imuha. Then you have to give them a reasonable nga like musulti kanila nga dala na sa korte kay gamiton ba na as evidence, di ba? And then they refuse man nga dalun dili man nila ihatag sa imuha. So dira na dayon nga ang court moallow sa imuha to use your own copy against them. So sa section 7 na ta. Ang section 7 is evidence admissible when original document is a public record. So, para mas madali siya masabtan guys, imagine if the original is a document from a government office, like a birth certificate or a title form from the Register of Deeds. Dili man na pwede kuhaon jud nimo ang original form from their files, di ba? And so the law says you can just use a certified true copy issued by that office. No need na to bring the whole file para makuha nimo sa korte. Kay dawaton naman na nila ang certified true copy. So the last one, section 8. Party who calls for document not bound to offer it. So okay, so listen. If you ask the other side to produce a document in court and then they actually bring it and you see it, wala ka na pugos na gamiton jud to as evidence. Just because you ask to see it, it doesn't mean nga you forced to offer it to the judge. So mao na siya ang pasabot sa section 8. Moving on to parole evidence rule. So, according sa Section 9, ang parole evidence rule is evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon and there can be, between the parties and their successor in interest, no evidence of such terms other than the contents of the written agreement. So, sa pagdali pa nga sabton, ang kanang parole evidence di ay kay nagsay na siya when you put an agreement gani in writing, that paper is the final word. Dili na kapidi mag-choose kay nakasuwat naman dira sa inyong agreement kung unsa inyuhang kasabutan. Ang parole evidence rule mao na siya ang no outsider rule. Like, for example ha, once you and your partner gani magput og agreement into a written contract, the law presumes na tanan terms, everything you talk about is already inside that paper. Inyo na nang kuan, like inyo na nang like kasulatan na dyan na ninyo sa inyong kuan agreement, contract, document ingana. So you cannot tell the judge nga kanang ay wait sa kanang naamang good me kanang pinky promise before we signed na dili na siya pwede guys ha, because wala man na siya sa writing. It basically doesn't exist in the eyes of the court. So you better make sure nga imuhang contract is complete or else malak-in jud na sa kung unsay naa sa paper. Take note of that. So here na ta sa requisite for admissibility. The document should be relevant. The documents should be authenticated and proven in the manner provided in the rules of court. The documents should be identified and marked. They should be formally offered to the court. The document should be relevant. So it means the evidence must be helpful to the case. Like if we're arguing about a car accident, guys, and why are you showing the judge a receipt of a Starbucks latte? It's totally unrelated, diba? The document has to actually prove or disapprove something in the case. If not, the judge will say, thank you, next. Kailangan connected yun na siya, guys. The documents should be authenticated and proved in a manner provided in the rules of court. So, you cannot just print something from the internet and say, mauna ni sa judge. You have to prove na legit na siya, guys. Like, you need a witness to say, yes, I saw her nga ni sign ani, or i-show nimo ang official records. Or like, ipa-authenticate na nimo jud siya, guys. Documents should be identified and marked. So, guys, nihatag na ata si ma'am ani og example sa pag-report sa group 1, but ata sa balikon. Every document gani needs a name so the court doesn't get confused. During the trial, the lawyer will say, I am marking this contract as Exhibit A Kailangan naa jud na siya label, bahalag kamo wala. Because if it's just a random pile of paper, the court will get lost. It's like putting names on your school supplies so they don't get mixed up with other organized din na siya dapat, guys, kay para mahibaw-an sa judge og sa dapat mahibaw-an sa judge, like katong example ni ma'am nga magmark ka dira like sa knife nga imo na siya markan og I heart Anya, I heart me, para mahibaw-an na nimo siya nga mao na siya nga ebidensya, mao na siya ang ebidensya nga nakit-an nimo didto. Here na jud ta sa final, they should be formally offered to the court. It means like this is the final move, guys. Even if the judge saw the document earlier, it doesn't officially count as evidence until the lawyer formally offers. Manidiri na ni siya nga time nga kung nagay kay ebidensya, dapat sa imuhang lawyer i-offer jud na niya sa judge. It's like saying, "Judge, here is my final entry." If you forgot to formally offer it man go, the judge can't use it in the decision. Sayang kaayo ang effort if you forgot this last step jud, guys. Dapat i-remember jud ninyo nga inyong evidence dapat ma-formally offer jud na ninyo siya sa court. Original document rule. Ato na sad ni siya naisgutan ganina sa katong best evidence rule. But here in section 3, original document must be produced. Exceptions. When the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original document itself, except in the following cases. So, diri sa ta sa original document, unya na ang except in the following cases. Like what I said earlier, original document, maujud na siya imong i-presentar, guys, ang original document. Pwede ra na nimo like ato ganing mag secondary evidence pag ma-prove nimo na imong original document is na-destroy, nawala siya, and ma-prove nimo nga wala nimo siya kuan in a bad faith. Here na dayon to ang exception of the following cases sa original document. So ang una is when the original has been lost or destroyed, man akong gisulti, or cannot be produced in court without bad faith on the part of the offerer. Muna nag-explain ako na ganina. And next is when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. And then when the original consists of numerous account or other documents which cannot be examined in court without great loss of time, and the fact of sought to be established from them is only the general result of the whole. And last is when the original is a public record in the custody of a public officer or is recorded in a public office. Ako na ni silang na-explain tanan ganina. Pero ako gyapon i-explain og balik para mas masabtan siya one by one. So when the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offender, this is the most common excuse. If the original is nawala jud siya, like nasunog or na-shredder by accident, the court will allow a copy. But, paminaw, you have to prove there was no bad faith. Meaning, dili nimo tinuyo o guba para lang taguan ang tinuod. If accidental jud, then you're good. Gora na with the photocopy or with the duplicate. Ari na ta sa B, when the original is in the custody or under control of the party against whom the evidence is offered. Paminaw. If gani, ang nagkupot gani sa original is imuhang kontra and they refuse gani to bring it to the court, kailangan na jud na nimo sultian sila in a reasonable notice nga kanang palihog ko dala ang original document kay para ma-present na, and ni-refuse gani sila og dalaan na, then dira na mo allow si court nimo na mogamit ka og photocopy. Ari na ta sa letter C, when the original consists of numerous account or other documents which cannot be examined in court. Sa diri, imagine guys, if the evidence is like thousands of bank records or accounts, if the court has to check every single page, mahurot ang time sa kalibutan, di ba? So the law says if it's too many to examine without wasting time, you can just present a summary or the general result. Sa dira guys, 'di ba i-summary nimo, pero summary it nga nagkuan gyapon siya sa lakatong as a whole gani siya sa pagka-summary nimo. Yeah, dira. And lastly is when the original is a public record in the custody of a public officer. Kana is dili biya na you cannot just bring biya the original and bring it out to the court. So dili na pwede ha. So dira na dayon to ang certified copy is already enough na sa court. The court trusts the government's filing system. So no need to bring the original. Okay? Okay. Purpose of the rule. So, the original document rule, or traditionally known as the best evidence rule, exists primarily to ensure that the court is looking at the most reliable version of a piece of evidence. In legal terms, it's about accuracy and prevention of foul play. So basically, the purpose of the original document rule is there to make sure jud na our justice system stays clean and accurate. Here are the specific purpose of the rule. Prevention of fraud, prevention of errors in copying, verification of physical details, promotion of truth, and completeness. So, prevention of fraud, kay mo din siya ang makatawag nga priority din siya kay if we always allowed photocopies all the time, someone could easily good nga ma-edit nila, ma-deletean nila o ganang sentence. Nya, by requiring man good the original, the court can check the physical paper for any shady business, anti-scam jud ni siya, not to fake evidence. In prevention of errors in copying, even man good is an intentional gani mistake when you copy stuff. Maybe the scanner was blurry or a word got cut off. Even one tiny typo can change the whole meaning of a law or a contract. Diba? The rule ensures we look at the source para walay sayop and everything is 100% accurate. Kailangan jud siya perfect. Verification of physical details. So, kani diri, there are things you can only see on the original, like the type of ink used, the depression of the pen on the paper, or the watermark of the stationery. You can't feel or see those on a photocopy man god. It helps the expert determine if ang dokumento ba is authentic or just a very good reproduction. Ma-feel man daw na sa mga expert ang tinuod o ang dili tinuod. So there is a promotion of truth and completeness. Nam gani uban gani nga contract or document nga 2 pages dyan na siya or tag 3 page or basig pila nga page niya na uban nga patara lag photocopy ang na photocopy kay ang first page ra and naa sa second page ang nakatanan kuan dito agreement and all. And wala man ka ana. Nya need man na nimo dalon tanan dito sa korte. So nawa na imuhang truth and completeness. So dapat naa jud na tanan everything, like literal nga everything. So waiver of the rule. Waiver of the original document rule happens when a party gives up the right to object to the presentation of a copy. If the rule is waived, the court will accept the photocopy or secondary evidence as if it were the original. So, a waiver means the other side basically says, okay, fine, you can use the copy. Mao na siya ang waiver. Like, musugot gani ka nga gamiton sa other party. Like, for example, ang iyahang photocopy, dili na ka mo object gani ana. So, like, the other side brings a photocopy to court. Usually, mo siya gid pa nag-objection, Your Honor. But if you stay quiet or your explicitly says, it's okay, Judge, that is a waiver. Waiver na siya nga, nisugot ka, you are basically giving up your right to demand the original. Once you waive it, the court will treat the photocopy as it were the original itself. So here is how a waiver typically works. Failure to object, express waiver, admission in pleadings, and cross-examination on the copy. Failure to object is the most frequent way the rule is waived is through silence. Under the rules of court, any objection to the admission of evidence must be made at the proper time. So if the other party presents a photocopy and you just sit there and don't say objection, the law assumes you're totally okay nga gamito na siya. By the time you realized, copy raman day to, it's too late na kailangan alert jud ka permi just to object immediately if dili ka ganahan, if dili na may consider nga katong photocopy iyang i-present nga evidence. Express waiver. This is a direct statement where the opposing party explicitly tells the court they have no problem with the copy. So kani siya kay very straightforward jud kayo niyang express waiver, like for example kanang when you or imuhang lawyer moingon nga, Your Honor, we waive the objection to the original document. Diretso jud kan ingon na okay ra. Usually happens when both sides want to finish the trial faster and nobody gadoubt gani sa photocopy. So mo na siya straight to the point jud ni ang express waiver nga mura gani kag ni waive ka nga o sige okay na gamiton ng photocopy, wala ra ko nag-doubt nga gipiki na nga naanay kanang something going on sa kanang photocopy. Admission in pleadings. If a person sued based on a document and they attach a photocopy to their complaint and the defendant fails to specifically deny the genuineness of that document in their answer, it is considered judicially admitted. So sa ari sa admissions in pleading, may tabo ni siya before the trial starts. Kay if they attach a photocopy to their complaint and in your written nag-answer ka nga you didn't physically deny it or you said nga yes, that contract mag-exist na siya, then you admit nga imo nang gibuhat kung unsa man to ang naa sa inyuhang written written complaint. Once gani nga nanana siya sa pleadings, dili na magud na kailangan mo produce og original because both sides already agreed it's real. Commitment magud na siya. Once you admit it in writing, lock-in na siya. And lastly, the cross-examination of the copy. If a lawyer starts asking questions about the contents of a photocopy during cross-examination without objection to it first, they are effectively treating the copy as valid evidence. This active use of the document constitutes a waiver of the requirement for the original. So it means, for example, if you start asking the witness questions based on the photocopy, you are now treating that copy as if it's legit kay mao man imuhang gigamit. And you can't use the document and then later saying, "Hala, I object because it's just a copy." Since imo naman siyang gigamit, already use it for your cross-examination, the law says you accept it. Kanang gidawat na nimo siya nga original copy na siya. Thank you for watching and listening. Next reporter, please.